Okay, I think I did it. Did I do it? Hello, I did it. Good morning, everyone. 'Tis I, lcadilac. Yesterday I was in court and I had to announce myself, and I said, well, first the judge said, is anyone here for the Cadillac matter? And I leapt up and I said, lcadilac, Your Honor, for the prosecution. No, for the plaintiff. That's what I said, the plaintiff. The judge was super nice. And I had watched him in the hearing before me, and he was just and fair. So that was great. It was nice to see. Welcome, everyone. Good morning. It's me, lcadilac. OG Cadillac Law. Morning, Jimmy. Morning, everyone who is in the chat already. Unpopular opinion. Kat Not Williams gifted 5 memberships. Incredible. Thank you so much, Kat. Thank you. I'm glad you found me. I've seen you in my stream. I unfortunately haven't gotten to watch much of your videos. It's been a crazy week for the Thug trial. It's been a crazy week for the Cadillac Law trial. Cadillac Law life. Thank you to Vonda. Sent me these gorgeous earrings. First time I'm wearing. I think they look like giraffe print, which makes me happy because giraffes are my favorite animal. I'm representing UT Austin today for my son. Hey, kiddo, if you're watching. I doubt it. I imagine my son's still asleep. All right, good morning, everyone. I'm so glad everyone's here, y'all. Just so you know, I have my volume all to the highest over here in the other screen. I have the countdown of the hearing that is going to occur today, and we are going to watch that together. Okay, so we're going to watch that. But before we watch the hearing today, we're going to get into everything that happened over the week. It has been a crazy week. It has been a crazy week, I think, for everyone. It's so crazy that I'm drinking like this hot chocolate drink thing. I never drink stuff like that, so. Woo! All right. As you recall, I went live on Wednesday from my home, which, by the way, guys, I'm never going live from home again. Y'all, there was so much criticism about my decor. It is my house. I will decorate how I feel like it. Okay? Never gonna let you guys in my house again. The hearing starts in 30 minutes, so we're gonna catch up, hopefully, in 30 minutes to where they are. Hey, Frederick, welcome. Okay. So on Wednesday, I let y'all know there was a new judge announced. Her name is Paige Whitaker, the Honorable Judge Paige Whitaker. It is my understanding that Brian Steele et al. Have had a fundraising event for her. And to me, that is a very good sign. I have also heard that this judge is very punctual. So I do believe that in 28 minutes and 2 seconds, we're going to be seeing the judge. It's not going to be coming on, waiting, you know, an hour of the camera on the Georgia symbol. I don't think we're going to see that with this judge. I think it's going to be... All right. You know, there is a difference in the way... There's difference in men and women. When I was at court yesterday, I don't know why, but this came up with the judge, and he said he had always thought that, you know, everyone was the same, and then he had a friend in his, I guess he was like in his 50s, his friend was like, nah, dude. And I said, yeah, I have a son. My son was 1 year old, he had little cars, and he's making this, this kid has never heard a car accident at this age, knows what that sounds like. Okay, so there's differences. My daughter's not making car accident noises. There are differences. There are differences between men and women, and there are differences in the way men run their courtroom and the way women run their courtroom, period. And we're gonna get to see that, okay? So I am very, very excited for this. Conditionally, of course, the DA wants a continuance. They would ask for that at this hearing. This hearing today is a status conference. So basically, I believe the defense is going to be able to tell the judge everything that's happened, all the bullshit, and maybe even ask for their mistrial. It's going to be exciting. I'm really excited for this one, okay? Okay, so as I predicted on Wednesday, there have been several filings into the case, okay? Brian Steele filed a motion to disqualify Love and Hilton. So let's go over that. Before we do that, I am lcadilac. Thank you for joining me, OG Cadillac. I'm glad you're here. We are following the YSL trial, and we have been since day one. And today we're going to get right into Steele's motion. And of course, when they go live with their hearing, we're going to go watch that together. All right. Hi, Enye. Hi, everyone. Good morning. All right, here we go. Y'all, I got this motion straight off of Twitter, right off of the Thugger Daily Twitter. If you're on Twitter, I highly recommend you follow Thugger Daily. This is where we get our daily news. So I want to shout out to Thugger Daily. Thank you. But unfortunately, I can't zoom in on this, so I'm sorry about that. But here we go. Jeffrey Williams files this motion to disqualify Love and Hilton. Williams is innocent of all crimes. As previously asserted, Love and Hilton have made themselves critical witnesses, including but not limited to when lawyer Love engaged in text messages with Archillian Bennett. Oh! Y'all remember that? Y'all remember that? Yes, shout out this morning to Kat Not Williams. She joined our membership and she gave 5 memberships for free. Thank you, Kat. That is so wonderful and generous of you. All right, so first he points out, hey, I'm calling Miss Love because she's texting with Archillian Bennett. Y'all remember Miss Bennett. Y'all remember Miss Love. Oh, don't you remember texting me? And we texted this and we texted that. Boom. And Love and Hilton and Glanville communicated with sworn witness Copeland in a critical stage of Williams' trial during the now infamous June 10th wholly improper ex parte in chambers meeting. Y'all, I just love how Steele writes. You know I be loving these Steele bombs. You know I love the hyperbole. Me and hyperbole, we go hand in hand together. I love it. I love it. I love it. He's so dramatic. It just makes me feel, as someone who tends to be incredibly dramatic herself, it just makes me feel more normal, I guess. It's like, okay, this is a really good lawyer and he is really dramatic. So that's cool. It's okay for me to be dramatic. I'm happy. It makes me feel better about myself. Like, okay, I'm in good company. I'm not the only hyperbolic, full of hyperbole lawyer out there, okay? I feel like it's partly our job to be that way, you know? We have to like really emphasize things and drive them home. The undersigned counsel has the duty to cross-examine Mr. Copeland, lawyer Love, lawyer Hilton, and Judge Glanville on all facts of the secret strategy session pursuant to the Confrontation Clause, right to present a defense, blah, blah, blah. This will mandate Copeland be cross-examined before the jury about his meetings and conversations with lawyer Love, Hilton, and Glanville. You guys, it drives me nuts that he did not put an Oxford comma here. There should be an Oxford comma here. This essential questioning injects the veracity and credibility of lawyers Love, Hilton, and Glanville. Undersigned counsel will also examine lawyer Love, Hilton, and or Glanville as to why they knowingly made false and misleading assertions to Copeland about the alleged disloyalty of Copeland's lawyer and provided legally incorrect information to Mr. Copeland in order to persuade him to testify against Mr. Williams. So Steele is saying, look, they're witnesses. This is what I'm going to ask them about. And he's not wrong. This is the truth. This is correct. Based upon their own deliberate and intentional concealed misconduct, Judge Glanville, lawyer Hilton, and Love's credibility and acts are now at the center in Mr. Williams' trial. Well, ain't that the truth? I mean, 2 months ago, there were like 7 people on YouTube following this case. All right. Myself included. And now, ever since the contempt hearing, everybody's all over it. Everybody's all over it. And hey, look, there's plenty of room to share. I do not believe in scarcity. I believe in abundance, okay? So there's plenty of space for all of us. But Steele is correct. This trial is now centered on this whole ex parte meeting. All right? So I'm just telling you about all the new YouTubers out there following, not YouTubers, but YouTubers now following this, is because of the meeting. So that's evidence to us that the meeting really is a centralized focus. That's all I'm saying. Okay. During the jury charge, it's expected that this honorable court will be asked to instruct the jury as to suggested pattern jury instructions the following. The court has no interest in this case. By no ruling or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of the case, the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of defendant. Undersigned counsel requires this above testimony from Hilton, Judge, and Glanville in order to have deliberating jury consider whether Glanville was, in fact, biased for the prosecution, and this jury instruction is not applicable prior to July 15th, the day Williams' recusal was granted. So, I mean, to me, that last sentence, which I'll show it to you, is like 4 lines long. It's a paragraph sentence, a sentence paragraph. Undersigned counsel requires this above testimony from Love, Hilton, and Glanville in order to have the deliberating jury consider whether Judge Glanville was, in fact, biased for the prosecution, and the jury instruction is not applicable prior to July 15. If the jury instruction is not applicable prior to July 15th, that is a mistrial. That is how you arrive at mistrial. Hey, jury, you believe that this was not applicable. The judge did have an interest in his guilt. That shouldn't even be before the jury. There should be no further question. The jury should not be contemplating those things. That's mistrial. Okay. Good morning, everyone. Thank you. Thank you for being here. So, Steele has asked again, because remember in his recusal, his supplement to recusal on Glanville, he added Hilton and Love. So he is asking again that Hilton and Love be removed because they are now witnesses. Thugger Daily reminded us this morning one of the first ever motions on this trial, May 17, 2022, was the state's motion to disqualify Mr. Steele. So, in May of 22, the state was trying to disqualify Mr. Steele. Mr. Steele has come full circle. That's a full circle. That's a 360. In May of 22, the state moved to disqualify Mr. Steele. Here we are, July of 24, Mr. Steele is moving to disqualify the state. Okay, so sometimes, let's say I'm working a case, I'm representing a client, and the other party files a motion for summary judgment. I don't know if y'all know what a motion for summary judgment is, but I will briefly tell you. A motion for summary judgment is basically asking the court, hey, we don't even need to have a trial. You can look at the record and you can make a decision without having to have a trial. You make a summary judgment. You make a decision without the trial, okay? So sometimes the other party, they file motions for summary judgment and my client freaks out. Oh my God. What are we going to do? Oh my God. We're going to respond timely. That's what we're going to do. We're not going to freak out. It is our job as lawyers. It is our duty to zealously advocate for our clients. So if we think we can win on MSJ, you damn well better believe we need to file one. So Miss Love, back in May of 22, thought she could try to cripple the defendant, Jeffrey Williams, by taking away his stellar counsel. We know he's stellar because we've seen him. And we all want to be like, wow, I can't believe she would do that. No, you can't be mad about that. That is part of the game. That is part of the game that is the practice of law. That's part of it. That is our job. It's our job. Now, it's also our job to think of the economy of the court. And if we know that we're not going to meet the burden or status to have that counsel removed, then it is our job to consider, do we really need to file that? But I've talked to you guys about this before. The state doesn't give a shit. They don't think about the economies. They have a limitless budget. Their boss prints money. Okay? Their boss prints the money. Not like us. Like my boss, my clients, they have to go earn money to give it to me, right? The state just the government can just print it. So state employees do not think about the economies, right? But they should. They're supposed to. We have a duty to do that. And we have a duty to not waste the court's time. But when you see that motion from Love back in May of 22, we don't need to be upset that she did that. That is, in fact, part of her job. That is what she should be doing. Okay. Another part of the job is to file a new motion for bond now that we have a new judge. YSL Silver Fox did this for his client on the 18th. Now remember, the Harvey rule applies. So to me, that means this also would go for Williams and the others. But I do believe we'll see Steele file one of his own. All right, comes now Marquavius Huey. Blah, blah, blah. Huey was booked on December 14, 21 and has remained in continuous uninterrupted custody without bond. We watched Karen Reed walk in and out of the courtroom every day. We watched Alec Baldwin walk out of the courtroom in the middle of court 2 days in a row. And this man's been sitting in jail since December of 21? Are you kidding me? You see me right now. We're looking at a renewed motion for bond from Marquavius Huey, and I'm sorry I can't zoom in on it. I didn't have it download. I'm sorry. I don't understand. We had people on trial for murder, and they walked in and out. This guy isn't even on bond, and has remained in custody without bond since his arrest. He petitioned the court for bond in September of 22, where the court denied bond despite proffering substantial information to the court to meet the Ayala factors for bond. All right, so Ayala factors must come out of a case called Ayala. And so here are the factors. The court shall be authorized to release a person on bail if the court finds the person poses no significant risk of fleeing, poses no significant threat of danger to anyone in the community, poses no significant risk of committing a felony during trial. And I don't have the second page. Sorry, guys. We're relying on other source. Okay. So YSL Silver Fox says, look, here's the things you need to find. Then he says, jury began in this case in January of 23. A jury was seated on November 1, 23, and opening statements started on November 27, 23. On April 8, 24, the trial court issued an administrative order regarding length of trial and noted the date of that order. Only 56 of 210 witnesses had testified by that point. This case has been labeled the longest trial in Georgia history. When a court has previously heard a motion for bond, its ruling is not subject to change unless the court finds that the movement has presented new information, testimony, or evidence that indicates a change in circumstances. Gee, guys, what do you think just changed in the circumstances? Judge got recused. Hello. In our case, all defense counsel, there's a bunch missing that I don't have. I'm sorry. Objected immediately to this ex parte meeting between judge and the state. The defendants were therefore entitled to be present and hear the meeting. As a direct result of this I don't like that he doesn't indent, you guys. If you start a new paragraph, please just indent. It's not that hard. As a direct result of this conduct, recusal motions were filed and the jury's been away from this case for several weeks, which we calculated is actually, what's it been? 1 month and 7 days. So it's been 6 weeks. Not several, 6. And they heard continued testimony from Copeland that they should not have. All of this conduct shall be considered new information, new evidence, and a change in circumstances requiring Huey and the other defendants be granted a bond. Huey and the other defendants have spent multiple days in custody during this delayed trial based upon the actions of the court and the prosecutors at no fault of their own. And it's true. Whose fault is it that we're in this position? Miss Lyon Love. It is Miss Lyon Love's entire fault. She asked for this ex parte hearing that Friday. Then she obviously asked for it again on Monday. She ended up in that meeting, leading that meeting. You remember I read that transcript. She starts the meeting off. It is her meeting. She hands it over to Miss Hilton when Woody comes in the room because her and Woody have beef. It's just absolutely nuts, y'all. Absolutely nuts. This is not how courtrooms usually operate at all. At all. It's been that kind of week. I've resorted to drinking hot chocolate, y'all. Okay. There definitely are 2 types of justices in this country. The Black Kink Couch podcast. Well, welcome to our chat here. Thank you for joining us, and you are right. And it literally makes me sick. Cowboy Hater Herder, welcome, says Melly has been locked up since 19. Yeah, I know. That's fucked up too. But my point is, we shouldn't be able to just limitlessly lock people up. These people have not been proven to be guilty. We are just locking innocent people up. Now, Melly is sitting there because he's accused of murder. So he's not allowed bail under Florida law. It just doesn't make sense why these people are locked up. Especially with Jeffrey Williams. This man has money. This man can sit at home with the ankle bracelet just like a gazillion other people throughout the country. Crazy. Nikki says, welcome to Fulton County where you can be locked up with a trial. Well, I mean, you can be locked up without a trial everywhere. It's just in our faces in Fulton County right now. Togla says, Alec went and grabbed a coffee during court and came back. The first day, when Alec Baldwin just got up and walked off, I never laughed so hard. I was like, I mean, I was in shock. I was in absolute shock. He just got up. He just stood up and just walked. His lawyers were in shock too because they ran up to the bench. Your Honor, we don't know what to do. Alec Baldwin was like, I'm a grown man. If I need to get up, I'm going to get up. And I feel him, man. I feel him. This is it. When the government has control over your life like this, it's just like being in high school. This is why you don't want to commit crimes. This is why you don't want to get caught for a crime. This is why you don't want to get sucked into their system. Because you're going to be told when you can sit, stand, eat, and pee for the rest of your life, you don't want that. You want to be a grown man and get up like Alec Baldwin. I mean, come on. Frederick James says, this case has been crazy the last couple of weeks. I cannot wait to hear your breakdown. Thank you. And thank you for the congratulations, you guys. On Wednesday, I let everyone know it had been 5 years of not drinking alcohol. One of the best decisions I ever made, and I highly recommend it for everyone. Your liver, trust me, your liver will thank you. Fanny Glanville loved Fulton County, that they could road young thug by attaching that bad word. Gang and RICO to this case, but they never went up against the likes of YSL Dream Team. Yeah, I think they have gone up against the likes of the YSL Dream Team, but just individually, never as like a team. And I don't know, man. Rereading that motion that Love filed in May, in May of 22, trying to get rid of Steele. I've been like, she has it out for Steele. She has like a crush on him. Like the anger competitive crush, not like the I want to be with you crush. Like, she's obsessed with him. I want to make that meme, you know, from Mean Girls, when it was like, why are you so obsessed with me? That is Miss Love and Steele. That is it. CJ says, in general, judges seldom reverse other judges' rulings and motions in the same courthouse. How likely would it be that the new judge would undo any of Glanville's previous rulings? I think it's actually highly likely. I think this judge is going to call a mistrial. I will be shocked if this judge does not call a mistrial. Really, I would. Let's see. Nikki Bloom says, if I was a juror, I'd throw myself down the steps to get out of this trial and get paid. Accidentally slip a banana peel on the floor. Oops! Oops! can't go back to jury duty. Oops, I slipped on a peel. Raynette, this court will start on time. I am sure of it. I have heard that this court is very punctual. So I do believe that will happen. Hello Life says, I was on GPS for 2 years, had to be in my home before 10 for robbery. I beat the case when I went to trial. Congratulations on beating that case. And you were allowed to be at home. You were accused of robbery and still allowed to sit at home. This man is accused of RICO, which, if you go back to my RICO video, is BS to begin with. And this guy is accused with RICO, and he has to sit at home. He is accused of associating with gang members. That's basically his crime. Let's see. Chris Tucker as Woody. Chris Tucker as Woody would be fantastic. This hearing is supposed to be starting in 2 minutes and 31 seconds. I've got it going right here in the background. I am really looking forward to seeing this new judge. So here's the thing. If defense attorneys are supporting the judge and throwing a fundraiser for a judge, that means to me, what that says to me as a lawyer, is that that judge is fair and impartial. That's what it says to me. You know, we don't always win. And a lot of times we know we're not going to win. Right? Like, a lot of times we know we're just going to go fight. Oh, here we go.
The state's table right now.
Here we go.
And some of the defense attorneys, if y'all would not mind introducing yourselves
They
and
are
tell me
early.
who you are representing, and at least for the first part of all this,
They are early. Early.
I'm going to ask that y'all use your name tags to help me. I think y'all had at one point like placards that you could sit in front of you. We'll find them if they're, I mean, it's fine for
Was she in
now.
Glanville's courtroom?
And I know you, Mr. Short, but good morning.
She's early, y'all. This is already a vast
I
improvement.
don't have to do it right now. I'm just saying, as we move, you know, for the
Okay,
first
Harvey's
couple
here.
of weeks at least, if y'all don't mind doing that for me. So, introductions.
Max Sharp, I represent Shannon Stillwell. My co-counsel is Mr. David Box, who is also here, and this next to me is Shaquille Kokomo. He has been working on the audio visual on behalf of some of the clients, including Mr. Stillwell, so he's been a big part of this case as well.
All right. Is
Shaquille Kokomo.
Shaquille
Are you an
Kokomo
attorney
is
or
the equivalent to
paralegal?
Lynn.
He's going to be a law school student.
Okay. Well,
He's college graduate right now.
fabulous. Good luck to you. All right. Thank you.
That's Shard's
Good
boy.
morning.
Carson Matthews Sr. here. I represent Marquavius Hughes in this case. I also have also represented Mr. Marquavius Hughes as my son, Carson Matthews Jr., who is not here today, and also attorney Teresa Mahfoud. They're all from my office, and we represent Marquavius.
Okay. And I had both of your names. I don't know if I have Miss Mahfoud's. Has she entered an appearance? Okay. All right. Well, we can update that. Okay. Thank you. Hey, Mr. Bucks.
She knows Bob.
Beth Weinstein, I represent Mr. Diamante Kendrick,
Okay.
along with my co-counsel Jay Apt, who's ill today, and Katie Garcia, who's on me.
Okay. All right. Hopefully, Mr. Apt will be feeling better
Thank you.
soon. You can pass
I like
that
her
along to
already.
him.
I'll do that.
All right.
Okay. Brian Smith.
Good morning, Your Honor.
Morning.
I am Brian Steele, and I have the honor of representing Mr. Jeffrey Williams, along with Dr. Keith Adams. Sitting next to Mr. Adams is a law student. He's a rising second year. John Marshall Law School. His name is Griffin Lail. Griffin Lail. If it's okay for him to sit with us. We appreciate it. If not, he will obviously.
Is he sworn in under like the Third Year Practice Act or? All right, so I guess he can just act as a paralegal for now. Okay, good to have you.
Okay, I adjusted the volume. I hope that helps. Echo.
Good morning.
Leah Oski here with Mr. Rafaelis Ryan. I am the secretary to Ms. Angela Williams, who is ill today. She's expecting a Zoom link.
She should be on Zoom, and I guess I should get on the Zoom as well. Give me a second to do that. Okay.
Oh, Weinstein has absolutely.
All right. Miss Rosser or Miss Persfield, will I find a Zoom link on my calendar or? Okay. Give me a second to get on there.
I adjusted the sound a bit.
Well,
Boss has been around since the hatchet was a hammer.
we came and tested everything yesterday, but of course the computer is not wanting to cooperate. Can I just go through the table for it? Trying to find my.
Okay, me help you help me. Please. I hope that sound is better. Everyone looks so happy. This judge probably knows a lot of these lawyers. I know she knows Brian Steele, but they have to announce themselves for the record. They stand up, just like I did yesterday. I stand up. I said, I'm Lauren Cadillac for the plaintiff. So you announce who you are. So they've said, you know, I'm so-and-so and I represent so-and-so. You got to do that anytime you're in front of a judge. Even if you've been in front of the judge on that case, if it's been a week, then, you know, you got to reintroduce yourself when you come in. So they'll probably do that. I don't know. She said for them to use name plaques, so she might not have them do it every morning. It's going to be so interesting to see what she thinks they're going to do with this jury. Okay, Kat, thanks for sending folks.
Yes. Just not by, I'm not seeing her on the screen.
Oh, Your Honor, I'm here.
Okay, are you just not on video with us?
Right, but I'm here.
Okay, all right, well, good to have you. Hope you feel better. If you might be sick as well, I think. Okay.
Sounds like everybody's sick.
Good morning.
Warren Gardner, on behalf of Marcus Nichols, and we have one additional paralegal, not paralegal, intern, here this morning, if necessary, we'll introduce you to him.
Okay, that sounds fine. All right, so a couple of things that we need to try to figure out from the outset. What is pending that I need to make a ruling on, and what our schedule is going to be like moving forward. I know there are already a couple of weeks that the jury has been sort of told you'll be excused for this week, so I will honor that. But I need for us to try to be efficient with the jury's time. So whatever we all need to get sorted out in the interim before we bring them back, as much as we can do, I'd like to do that so that we can minimize the times when they're here, but we have to send them to the jury room to figure out things that we could have figured out before. And I know sometimes that is going to be unavoidable, but to the extent we can avoid it, I'd like for us to talk to each other beforehand, give each other a heads up about what is going to be coming in or what we think might be an issue, and deal with it without the, wasting the jury's time, basically. So, Mr. Steele, on behalf of Mr. Williams, sent me yesterday a list of what he believes to be pending motions that still need a ruling. And I think I have one that I know of from Mr. Huey, and I'm just going to kind of hear from each party as to what, as the state as well, as to what y'all believe is pending that we need to get heard. And since I've already got Mr. Williams' motions written down, I'm just going to make sure, Mr. Steele, that I've got all of the ones that you believe to be pending. So I saw in your email a July 8th and a July 9th motion to recuse both Judge Glanville and Judge Krause, which I'm obviously, we're not going to do anything substantive here today. I'm just going to make sure I know what y'all believe to be pending. A July 10th motion entitled for a fair trial that is essentially to find out about whether there have been any other ex partes. A July 1st motion that's kind of a proffer about something that happened with a jail call, evidence that's already been taken care of. And I mean, I'll look back into that. But a July 18th motion to disqualify two of the prosecutors. A July 10th motion asking, I guess, prospectively for a fresh look maybe at 248801. And then you had also provided an amended witness list and a notice of filing. Are there any other pending motions for Mr. Williams that I didn't include?
It's not a motion that filed. May I address that just for your edification?
Sure.
Okay.
And are you going to file it? You're just giving me a preview, or?
I could file it.
Okay.
I'll do whatever the honorable court desires. So I just want to bring to the court's attention, to be, fair to the
Okay.
court. May I approach, Your Honor?
Yes.
I'm not on mute. My mic was
And
too
it'd
low.
be easiest
to just hand it to
The
first field.
what I was going to say is the court reporter works for the judge and goes with the judge wherever the judge goes.
I want to make sure that my staff has cell numbers for everybody.
Honorable court's co-worker and the state, two cases, PROPST versus Morgan, MORGAN, and it's 288 Georgia, 862, 708 Southeast 2D, 211. And if you look at page 2 of the copy of the case that I've handed to this honorable court, and the state, on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially denied, he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes?
Was there a written order?
He did file a written order
June the 14th.
Okay.
2 days later,
All right.
and that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted. Judge Krause, in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I don't want to, I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added to the list, but I appreciate that.
I'll file
Thank you.
today. Can I add one other thing just for your knowledge? But
Sure.
if it's something that's more than a status, then I will withdraw it.
Yeah, and I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
Understood.
I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying.
This judge has not done any homework on the case, as she's not supposed to. She's not supposed to know about the case. She's coming into this fresh and blind. So this is the first she's heard about any of this, hopefully. Hopefully.
His name's Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the motions.
Great. Okay. For Mr. Huey, I have got a renewed motion for bond. Is there anything else for, I don't even know which party I'm looking at yet, but. Okay.
Huey, that is the only motion that I've got at this point.
All right. Yes, thank you. Okay, so for Mr. Stillwell.
So, Your Honor, the way that we had been operating under this case, under the Honorable Judge Glanville was yes, sir. Your Honor, the way that we had been operating under Judge Glanville was there was a thing we named the Harvey Rule, which assumed that all were in agreement in opting into a motion unless we specifically opted out of the motion. So
everybody's joined on everything.
Appeal has filed a number of motions that we opt into. And Your Honor, I'll also just point out, there's also the gentleman who's on the stand right now. I think that we need to have a hearing regarding the admissibility of his testimony. I'm not looking at Mr. Steele's motion, but I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand and what he said.
Okay.
And additionally, after Mr. Weinstein's recusal motion, we spent a significant amount of time going back and forth about prior statements and redacting prior statements. And I believe that
prior statements of Mr. Copeland. Okay.
We would have to go through that process again because that was done after the Mr. Weinstein's recusal motion. So we probably need to relitigate that as well. Of course, if it doesn't fall under a hearsay exception, then we wouldn't have to do that. But But it does. And Glanville made a bad ruling, so now we got to go through it again. And look at how defeated St. Nicky Hilton and Lion Love look. Love's under eyes are so puffy. They're not matching.
With regard to the question of the admissibility of Copeland's statements under the co-conspirator rule, is there a pending motion or was there an oral motion? Has there been a ruling?
There was a ruling.
Okay.
I don't recall if it's been reduced to writing. I'm going to assume it was. But you know, we've litigated a recusal motion. We've talked about the appearance of impropriety at this point, and from our stance, we need to relitigate into substance, but just to educate.
But is that what you're saying should be reconsidered? Okay. All right. I am not going to go back. I mean, this case has been going on for how long? long, 6 months, at least the trial part of it.
Try 7.
And obviously, I'm parachuting in, and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made, and I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that.
Just all the rulings on that.
On Mr. Copeland. Okay. All right. All right. And let's see, for Mr. Ryan, and I understand everybody's basically joined in on everything we've already talked about. Is there anything that's individual or in particular to your client that I need to think about?
Yes, Your Honor. And hopefully the state will correct me if I don't have the correct place. But some of what specific evidence the state plans on using witness has been specified somewhat on a rolling basis.
Okay.
I'm going to give an example. In Mr. Ryan's case, there are 15 recorded interviews.
Mm-hmm.
The state is not necessarily going to offer all 15. Within the ones they might want to offer, there are parts which are inadmissible. Everyone would agree they're inadmissible, but the state has not had a chance to sit down and specifically say, we want these statements, and here's what needs to be redacted, and go back and forth on that. So we've not crossed that bridge yet for Mr. Ryan. When we do, you'll have motions of that nature.
Okay, so I'm going to try, and we can maybe get to that in a minute, but I would rather everything that should have been a motion in limine get sorted out. I don't care if we're 2 months from that testimony. But
that's absolutely fine, Judge.
yeah.
Describe it on a rolling basis is what.
Yeah, well, to the extent we can stop that, we're going to try to get everything done beforehand, but we'll see. We'll see. All right, thank you. And then who else have I still not heard from? Ms. Ford.
Okay, guys, motion in limine are pre-trial motions heard before the trial begins, not in front of the jury. So the judge is saying, I want to get our motions in limine done before we set anyone else again. This means this woman is managing the courtroom. I am very happy so far.
Mr. I will, y'all, in a couple of weeks, I'll know all of this, but I just honestly have not been following this case up until now. So, Mr. Harvey, for Mr. Nichols. And I may need you to yell.
I'm sorry. Better?
Yes.
Per the rule we've been operating under, we're all in on everyone else's motions, barring a on the record opt out.
Okay.
So we're in on everything because we have not opted out as of this point on any of those motions.
Okay.
There may be, I to be honest with the court, I wanted to see where we were today, what our plan was. There may be some additional motions that would be filed on behalf of Mr. Nichols, and perhaps other defendants. If we're going to view this as sort of a logistical status conference, based upon prior proceedings, we've mentioned certain things. We've mentioned certain cases about what may or may not be valid or evidence post motion to recuse. There may be some additional motions that need to be filed. So I would ask that on behalf of Mr. Nichols, that not only we're opting in and we need to now think about whether or not there's going to be any specific opt out, but to give us some time frame to file any additional motions based upon the unusual proceedings and circumstances in this case moving forward.
All right, so I'm not going to be able to give you a blanket, hey, you get X amount of days to file whatever you want here, because I don't know what it is that you might be contemplating. And frankly, there have been, at least a week and a half that's gone by since whatever the ex parte was that caused all of this. It may be that it's appropriate for another motion to be filed and be considered. It may not be. I'll kind of have to wait and see sort of what it is and why it is only now that it is going to be filed. So I just can't give you an answer on that before I know what it is. But I mean, I'm certainly not precluding anybody from filing. I just don't know if it's something that could have been filed 10 months ago, then I probably don't want to hear it now.
No, I think these circumstances are unique, clearly. So it presents unique opportunities to now move the court now that we have a court. I just
okay,
don't want
so why don't I just say that if you are
Lion Love didn't like that one, did she? Shaking her little lion ass head.
contemplating anything, contemplate it quickly and get it filed
5 business days?
Before the end of next week, because, and I want us to all look at a calendar in a few minutes, but, the jury has already been given the week of July 29th off, so they won't be back before August 5th, really. So I would like for us to, if we're going to be moving forward with this case, to be able to move forward with it and have all of whatever this is going to be out of the way before then. So if you can honestly, because I would also like a response from the state on anything that gets filed. So if y'all can, given that you've had already, a week and a half since whatever went down. I don't know the exact dates of everything yet, but you don't really need 5 more days to think about it. I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but that is what it is. And then
deadline.
Responses from the state by that Friday, the 26th. Okay? Which does not mean I'm inviting them. It just means if there are some necessary ones that we need to consider. Obviously, I want them briefed by both sides. And then we'll probably spend the week of the 29th we'll all be here without the jury trying to get as much done as possible, I think. Okay?
And that may answer my next question. I know that on behalf of myself, and I know various other co-counsel, as soon as the words "we're in recess" were uttered, I have emails, special set trials. I am inundated by other both federal judges and Superior Court judges. I am asking for protection, and I would assume that co-counsel would join in this protection so that I can say to these other judges, I am on trial. I'm required to be participating in this court, and you cannot set me for trial in another court because I'm on trial. Can we get that protection from the court?
Yes, you shouldn't even need that because we are in the middle of a trial. I don't care whether the judge has changed or not. This trial is ongoing. But yes,
I have had to ask for that before. I have had a judge schedule something in the middle of another thing that was scheduled, and I said, okay, I have this other thing scheduled, so if the judge takes issue, can I refer him to speak to you? And the judge was like, of course. And the other judge did not take issue. I simply said, this judge is commanding I be here, and they get that. All right, this judge doesn't know anything about this case, and she shouldn't. All of you should be happy that she is completely ignorant to all of everything that's gone down. That is how it's supposed to be. So this judge is doing her job. I'm very, very happy. Very happy.
extent that any judge calls at my chambers, yes, I will tell them, sorry, you can't have Mr. Harvey right now. I've got him.
I want to make those representations in conflict letters. I want to make sure that I'm doing that properly.
Yeah. Now, if there is, because I have been until recently one of the people trying to get a hold of all of y'all for other cases. So if we decide we're taking a 2-week vacation in August, which we won't be, but you know, hypothetically speaking, and y'all aren't in here with me litigating something, then I'm probably going to say you're available, not for a trial, but for, you know, a 1-day hearing or something.
Yes,
Yeah.
I don't mind the one-day hearing. I do mind going to trial when I'm
Sure.
on trial.
Yes.
So with that,
Y'all are all protected from being expected to be in trial anywhere else until the end, completion, however it completes, of this trial.
thank you.
Yes.
Thank you.
All right.
Your Honor, Doug Weinstein for Mr. Kendrick. We have no pending motions other than what has already been stated by our defendant's counsel that we all join in. We will be filing motions before Tuesday, but we have no pending motions. And you said we are going to discuss calendar moving
Yes,
forward?
yes, yes,
Okay, I have
yes.
some comments with regard to that.
Okay. All right. All right. Turning to the state. Are there pending motions by the state that need a ruling?
Oh, here we go.
Thank you, Your Honor. There are, and we will have to the court before Tuesday of next week, as the court has made a deadline. There are responses to recent filings by some of the defendants that the state anticipates it will be making. And there are 2 anticipated motions in limine that we will have filed by Tuesday.
Okay.
Based on the court's earlier instruction today, there were matters that are more appropriately placed within a motion that we will have to the court by Tuesday as well. There are, and we will identify all of the ones that we believe exist. There are outstanding, there are rulings that have been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list as well. Thank you.
Of course. And we also intend to address, we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, all of the exhibits that have been tendered, ruled on, and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that. Or if the court will permit us or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare.
No, we would never be ready.
If the defendants each
we
have
would never
one,
be prepared.
because we want it to be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
I would have preferred that the court just order that each of us present to the other the exhibit list that we have, to the extent that they do exist, and that we then endeavor to iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not been admitted.
Okay.
So we are asking for a date.
Oh, right.
Okay, so when can you have yours ready to dole out to everybody?
We can have ours ready by Tuesday if we can exchange them by Tuesday.
Okay.
She just cannot present anything without slinging mud. I swear to God. It's unbelievable to me. Oh, well, now there's evidence they said was tendered, but it wasn't tendered. Your time for objection was when they said it. I hate her. Hearing her voice again is like, making my skin crawl.
Is it, I assume everybody's been kind of tracking this. Could everybody have what you think is the state of the evidence by Tuesday?
I don't think that's going to be hard to do. It's okay.
I mean, frankly, whatever the court reporter has is what's accurate. So it might be that I can just get that list from the court reporter and give it out to all of y'all.
There's an idea.
If there is that might be a better way to do it. And then if there is a discrepancy and anybody who believes that's inaccurate, we can take it up. So why don't
there
I
we go.
talk to and we're going to be, from now on, well, y'all all know Miss Parker, but Miss Parker is retiring in 1 week. I will have a new court reporter, and I know, it's the end of an era, but I'll have a new court reporter, Ms. Winfrey, who probably a lot of y'all know anyway, and she'll be moving forward. I'm going to ask Judge Glanville's court reporter to start working on transcripts, because I'm going to need them, but we'll all need them at some point probably, because just transcribing what's happened so far is going to take months and months. So we're going to shift not only judges, but also court reporters. So I will get with Judge Glanville's court reporter and ask her to give me a list of what has been tendered and either excluded or admitted or is still hanging out there. Give that to all of y'all, probably just through email from Ms. Rosser. And then if there is any discrepancies, y'all can let me know that, okay?
That would be great. Does the court, and I understand that there's really no way to tell accurately, but does the court have any idea of when we could anticipate receiving something
I
like
think
that?
pretty quickly. I mean, I've had a couple of communications with her already, and she seems pretty on the ball, and she's tracking it all on an Excel spreadsheet or something. So I don't think it'll take long. I think I can get y'all that by next week sometime.
Thank you.
Okay. Let me write my to-do list. Okay.
Lion Love out here just always making these flagrant assertions that the defense is doing something wrong. It's unbelievable. She just cannot. She can't win a case without the defense doing something wrong. That has to be it. That has to be it. There's no, I can't think of any other reason for her to keep doing this stuff.
Your Honor, I'm reviewing all of the notes from representations made by counsels for each of the defendants, and based on my review of those notes, I don't believe that there are other matters that we need to address at this time that are properly addressed without the defendants here.
All right. And do you have an idea of when you can get me the list of the rulings so far?
Yes, Your Honor.
And I know that's a bear of a task, so that's okay. Don't want to be unreasonable about it.
Just 1 second, because we have already begun that process.
Right.
And let me, if the court will permit me to confer with our team members who are working on that.
Thank you.
Thank you.
Standing in for Mr. Williams today.
I'm actually in on the case. I did file an entry.
Okay, thanks.
Whole different Miss Love today. Whole different Miss Love today. Oh, she ain't the boss no more. She ain't running this courtroom no more. This is why I was so excited to see this judge. This is why. Let me see Miss Love asking permission. Let me see Miss Love explaining herself.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great.
Okay.
Thank you. All right. With regard to the most immediate scheduling, the kind of getting through, hearing argument on, getting rulings on the things we all just talked about that are pending. Is everybody available and I guess I've already got y'all, unless Judge Glanville had excused you, I think I've got y'all, but is everybody available? And I'm not saying we're going to be here 8 to 5 every day, the week of the 29th, but is the week of the 29th, everybody's available to the extent we need all of those days?
Stays available.
Okay. Anybody not? Okay, perfect. Because I'm thinking that at least most of that week, that's what we're going to be doing, which means I am not going to be going to the judges' summer conference, but that's okay. That's okay. Okay.
This, a public servant actually serving the public. Oh my God. A miracle. She's going to not go to a summit that she could go to so that she can actually move this case along. I'll be damned. I swear. It's like, it's night and day between her and Glanville.
All right. With regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. And I'll have to obviously make sure that all the jurors can do that. I don't know what their, pick up kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here and have them. So that's kind of going to be my plan going forward. And it may be that we want to go all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon.
She's going to make these people work.
August 5th with the jury. We may have so
Y'all
much
doing your
work to
job.
do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay?
She is not playing, y'all.
I don't want to be waiting around till 9:30 to get started. 8:45.
This is what we should have seen years ago. Literally years.
Right,
We
so
should have
that's
seen
that. So a couple of things have been brought to my attention that some people might like changed now that we're have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Ross or y'all.
You know what she's talking about? She's talking about Yak Gotti. That man dresses so well. I had noticed none of them have repeated an outfit. I noticed that. There has not been any outfit repeats, which is something I'm a huge fan of. I guess that's a burden on the bailiffs because they have to watch those clothes for them. That's hilarious.
Oh no, Miss Rosser, I think she's not even here today. Yeah, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing. You know, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out
5 new outfits a week. Hello.
So now I've done that for the deputies. They'll be more happy. Okay, next topic. Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And we'll just leave it at that for now. There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening, and that raises some security issues.
Busted. It had gotten real lackadaisical in that courtroom. There were a lot of defendants kind of doing their own thing, playing on cell phones, so on and so forth. She heard about it. Not in my courtroom, she said. Oh, man. We are seeing a real judge do real judging now. Like, this is how it's supposed to work. The judge is supposed to have rules in their courtroom. You are supposed to follow them. I think the disruptions piece has to do with Miss Love's neck. That's what I think. All right, let's keep going.
With our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary?
No, ma'am, I couldn't speculate.
Then we'll just do away with it.
No, ma'am, I could not speculate. No, ma'am, I have no idea. No speculation here.
It was originally combat boredom.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew. Okay?
Sure.
Yes, sir.
Good morning again, Sergeant Matthews, Mr. Huey. There are times where the defendant might need to listen to evidence, interviews, things of that nature. And I've made that available for my clients. We can listen to some of the interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
Certainly understand that. Just maximizing the time that I have with my clients since I don't have availability with him outside of court every day. So he's here, we're here. So a lot of times I'll give him an opportunity to review evidence and things of that nature. So
Right.
that would be the only reason I would ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right.
She said, I'm going to run my courtroom like a courtroom. I'm going to run my courtroom like a courtroom.
I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered an order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption. But at the same time, you know, maybe some of this can be whittled down. And that is a wild paraphrase of that order, but I think y'all know what I'm talking about. What I want to know is, where are we really? I mean, I know, you know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly. Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence. And I might end up using that. So how about y'all give me a heads up on all of that, okay?
Okay, Stacey, so go do your job.
If that is something that y'all could have to me by next Friday for everybody, that would be great. Let's see, what's next on my list?
Damn, y'all. She got a schedule. She said, I need to know who the witness is and what they're there for.
Scheduling, other than the week of the 29th, and then I was told, I think Monday through Thursday of August 19th through 22nd. Is anybody aware of time that has already been given to the jury as you're out of court this week? You have this week free? No? Okay. All right. Does any attorney right now know of a date that nobody from your team can be here? And I wouldn't expect that to be the case because y'all are in trial, but no, I mean, anybody getting married? Okay. So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. the little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But
she shouldn't even have to. She shouldn't even have to.
If
say
it
that
gets
stuff.
to a point where I think that is not being carried out appropriately, we're going to
She's
all
looking
have
at
to
Miss
talk.
Love.
Okay.
She's looking at Miss Love, y'all. Wow. Wow, wow, wow.
All right, what else do y'all think that I need to be thinking about, or do we need to be talking about, or at least raising to talk about later? And anything from the state?
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Okay. All right. Mr.
That's a whole new Miss Love. That's a whole new Miss Love.
Okay. Mr. Sharp, anything?
There have been, this case, as you know, is enormous, and the discovery is enormous. There are certain, with Judge Glanville, we have some general rulings about some matters, but not particulars.
Okay.
I'm trying to give a heads up. This is an example, but I don't think this is the situation. I have filed a motion regarding, there was a wiretap in this case.
Okay.
And the judge overruled my objections and stated that the wiretap was legal. He made that finding. However, there are other issues about the wiretap and the particular things said in the wiretap. Some of those pieces of communication may be admissible, may not on an individual basis. Certain things like that, I'm just giving the court a heads up, have not been parsed through to the particulars.
Okay.
And we've discussed like the need to do those things, and some of those things we've kind of kicked the can down the road a little bit.
Mm-hmm.
So there's still out.
She's wagging her head. Miss Love's wagging her head. She does not like this.
Maybe when everybody is putting their lists of witnesses and what they're generally going to be talking about together, they could also, I don't know what happened to my mic all of a sudden. They could also include, if there's any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all can maybe list out for everybody what that is. Because yes, I absolutely want those things to have been determined before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now.
But you can't, because you're not. Nope, we get new evidence. We get new evidence every day.
Reports that we're still missing. The state has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing.
All right.
That's been a recurring theme.
All right. If everybody
Chart is
wants
hard
to
for those
detail anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist, that'll be something we can take up substantively, just so we start out all on the same page. That'll be something maybe y'all can do next week, and we'll take up the week after that as well. Okay, because if we need like 5 days of motions in limine, we need to do that.
Look at her deep breath. Oh,
Judge, I just wanted to make clear that it has complied with its discovery obligations that we have turned over all of the discovery that exists in this case. And as the court is aware, discovery is that which we have so we have turned that over, and we've actually gotten and requested, we've sought from outside our office any other materials that existed in the universe. We will do as the court has instructed and provide to the court a list of matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And
She always gotta get that.
I know you've been in my courtroom before, and typically I have, one side or the other list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. All right.
This is awesome. This is beautiful.
For any evidence that there hasn't been a ruling on yet that I'm going to need to consider the admissibility of, I obviously am going to need a copy of that. So if I've got 5 hours of some audio to listen to, I don't want to listen to that in court. I want to listen to that beforehand so that I know what we're talking about before we get to court to hash it out. So get me all of that as well. And that'll be more homework for me to do.
Wow, a judge that actually wants to be prepared. What a delight. She actually wants to be prepared and do her job.
Then, so let's go through anything, either Mr. Williams or Ms. Sabasi for your client. Okay, Mr. Harvey, Mr. Steele.
No, not
Okay. All right. Okay, the next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody, while we are kind of in this pause, to talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain any kind of plea at any time. It can be a joint recommendation. It will be non-negotiated since we're in the middle of a trial, but it can certainly be a joint recommendation, or it can be state wants this, defense wants that, or it can be we all want to keep going with this trial. I'm here to do.
We going with the trial. We going with the trial.
Follow the law. But I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that. Okay.
No, 2 years ago would have been a good time to do
I
it.
think that y'all have a lot to do and I have a lot to do, and we will plan to get all of our filings and all of our responses in before the end of next week at the dates that I had provided. And why don't we plan to maybe not Monday, but Tuesday, the 30th. All convene here at 8:45 and just start tackling everything that got filed, okay? And we'll plan to go pretty much all day until we finish every day that week.
This is exciting.
And by the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week.
Or if we're calling it a
Anything
mistrial.
else from anybody?
I have a question, Your Honor.
Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress for instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said, I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern evidentially, constitutionally. I don't want it to be,
Love's face, y'all, her face.
Under the sun. So I don't know if that answers your question, but
that is the stinkiest face I ever saw.
There are chunks of evidence that everybody has just basically not gotten to yet, and y'all have sort of said, all right, we'll get to that when we get to this witness. And if y'all have been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then if that's what the expectation has been, then I wouldn't expect y'all to have all filed all of your challenges. I don't know what's been going on.
Nothing's been going on, Judge. No, that has been the case.
Indicated that the court wanted parties to provide evidence regarding admissibility issues. I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is ripe and what is valid for contesting at a particular moment. I don't doubt those will continue to arise, but I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I.
Okay, so I don't intend to revisit rulings on evidence that's already come in. But for evidence that we know is out there and was going to be introduced a month from now with, witness Jones, if y'all have been doing that on a rolling basis and y'all know that there are going to be evidentiary issues with it, things that I would have considered motions in limine, then I want us to all go ahead and voice that now and sort it out so that we know when the witness shows up what can be talked about and what can't be. And I don't know if that gave you clarification. Okay. All right.
Keith Adams did.
If I may, I have to disagree with Ms. Love. It's been going along that we've already had motions about what is and is not admissible. Just to propound on kind of what your Honor was mentioning and what the task of defense faces, we have a list of 8,000 jail calls. We haven't listened to 8,000 jail calls, and I think probably the majority of them are not relevant. Everyone would agree that they're not relevant. The state's not actually going to introduce all of those jail calls. However, defense are a burden. If we don't raise the objection, it's been waived, and then it comes in at trial.
Okay, so that's why the witness lists with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram is going to be these ones.
Okay.
And Judge,
yes, sir, Mr. Adams.
Good afternoon. Again, Judge Keith Adams with Mr. Steele for Mr. Williams. I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just append to what Mr. Biden was saying. For example, there have been your jail calls, there interviews, that generally speaking, there have been hearings on the admissibility of those statements.
Okay.
But the court has oftentimes said, I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that
Okay.
at that time. The court has routinely been doing that, so not necessarily kicking the can down the road, but addressing issues as they come up. And the court has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that, but there have been routinely times where we said we just disagree and we've had to take those items up. And I think what you would like, what Judge Landfill has asked, is that let's let you know about it as far in advance as we can. That way you can set aside some time to deal with it.
This love is over. Just
Absolutely.
look at her.
I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can, and litigate everything that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it 1,000,000 years ago, their updated list that they're going to share with everybody should not include the Instagram post that they know they're not going to use.
Okay. John, thank you for the $5 super chat. Thank you so much.
I will expect whatever filings y'all, I will anxiously anticipate all of them. Make sure whenever you file anything that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it.
This is beautiful. This is how courtrooms run on a daily basis. Most courtrooms in the United States run like this. Most courtrooms I've been in run like this. You do motions in limine before trial. You don't just pop up new evidence. Okay, so the contrast is so stark between her and Glanville. And I'm glad we had Glanville, because we can all see what an out-of-control judge does and how much power they have. And now we're able to observe what an in-control judge does and what a real judge is supposed to do. So this is beautiful to watch. It is fantastic. And watching the defeat on Miss Love's face, it's just, you know YSL Steel is eating this shit up.
To see everybody bright and early at 8:45 on Tuesday, July 30th. All right. Don't leave until you make sure Ms. Rosser has your cell information.
Can I ask a question?
Yes.
Judge Glanville had, for both sides, 2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that continues. That would be very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing rule. And I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand. And the state knows, we're in the state's case right now. The state knows what it's doing. The state has investigative help. Make sure you have enough witnesses to carry us through each day and that they're ready to go. Again, that all just kind of falls.
Okay, no breaks between witnesses. No more comfort breaks.
Can I assume, Judge, that we are going to continue with the opt-out rules so that you're not going to get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if there is something, y'all can bring it to my attention. Otherwise, we'll just keep rocking as before. All right, thanks everybody.
Remember the press, there was a rule in place for the members of the press to get the witness list on Friday, so someone will be excluded to be shown on camera. I want to make sure that's still in place as well.
Okay, so I guess y'all would have agreed beforehand that a particular witness shouldn't be shown on camera. And then who gave the list?
The state
No,
is
nothing
going to
happened
provide
beforehand.
to members of the press the list of those persons, and the judge has made rulings regarding those.
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown, whatever kind of concerns, then they won't be shown in the, but
It wasn't exhaustive.
it seemed that that was kind of a witness by witness thing, and that there was an opportunity for input.
Yeah, there's an order that
Yeah.
the judge entered, and there were certain reasons that the state
Right.
could request that
Yeah.
witnesses not be televised. I believe that was to be provided to us the Friday before, and then we would have the opportunity to
Right.
get to that by Monday.
Right.
And then the judge would make a decision
Yeah.
based on his criteria, whether that witness should be shown on television or not.
Right.
And I believe
Miss
that
Love's
Mr.
face.
Harvey has a standing objection to all witnesses.
Miss Love's
at this
face.
point.
Okay.
Miss Love's face is
Wait,
making
to
me-
all witnesses being shown or being excluded? Okay. Well.
No witnesses excluded. I don't want to speak for Mr. Harvey.
All right.
And I'm in concurrence with this.
Okay, well, that's why I guess it's being taken up on a case, witness by witness basis. So, Ms. Love, then you're providing that to the court and the opposing counsel. If there's objection, we're litigating it. And then are we saying it's like the next Friday that we then tell the press, or help me out on that?
Ms. Hilton says she has been providing that list. I will let her explain to the court.
Okay, because I guess I'm wondering, how is there a list if there hasn't been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially
Okay.
prepares the list.
All right.
Good morning, Your Honor. Or
Good afternoon at
Your
this
Honor.
point.
What has happened is the week before, certain witnesses were going to come up the following week.
Okay.
We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as opposing counsel. They would then decide, object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state is kind of the preliminary. We think this might be the case list. But Ms. Hilton, do you then give them and here's what our determination was list, or?
So normally the court has put on the record that Monday, whether or not that witness should not be shown.
Okay, so y'all you've got your list and you either strike that person off because I said they can be seen, or you just go with what's on there. Okay, that makes sense. So yes, we'll continue with that as well. All right, we're in recess. I'm not muted. I just had the mic really, really low. Sorry. This is exciting to me. This is thrilling. This is how a courtroom is supposed to be run. This is what we usually see. Yesterday when I went in the courtroom, this is how the judge managed it, right? This is my courtroom. Here is how we're going to run things in my courtroom, right? So to see this is oh, thank God, so refreshing. So refreshing. And we all know that this judge runs her courtroom by the look on Miss Love's face.
Oh my God, I cannot even. Okay, a lot of you are asking in the chat about the bond hearings. And what about the bond? They are not going to have bond hearings without the defendants present. The defendants have to be present anytime something substantive that has to do with them occurs, okay? Today was simply a where are we, how do we move forward day, okay? That is it. Today was a where are we, how do we move forward? And what the judge said is next week, from today forward, you're doing motions. So if you have a substantive motion, a motion in limine, a motion to suppress evidence, a motion for mistrial, a motion for bond, all of those, that needs to be filed by Tuesday, July 23rd. The state's response is then due Friday, July 26th. Then, on Tuesday, July 30th, everyone is coming in. Okay, John, thank you for gifting the 5 memberships. That's amazing. Amazing. Everyone who just got a membership from John, please say thank you. That is awesome. Thank you so much, John. You're amazing. I truly have the best chat on the whole internet. And we got a little nickname called Catty Chat. I love that. I love that. So thank you for my chat. Thank you, everyone. Okay, so July 30th, they are going to come in and do the motion hearings. They're going to begin on July 30th and then work their way through that week. I believe they're going to start with a mistrial. That's what I would ask. I want, like, hey, let's do the mistrial motion first. That way we know if we even need to proceed or not. Okay? So I'm guessing on the 30th, the first thing we'll hear is the mistrial. If she does not call mistrial, then I think we would probably move into bond. Then we would move into the motions in limine. So like I've told you, motion in limine is a pretrial motion. Any pretrial motion, pre-jury. And like she said, if I had been running this trial, we already would have done our motions in limine. They are done before trial. Glanville, for some reason, is doing them while they're going in trial. It makes no sense. It's no way to manage a courtroom. It's a terrible way to manage a courtroom, as we saw. Okay, so on July 30th, I will actually be going on my little vacation with my daughter. We're going whitewater rafting. I will live stream on August 2nd. But it'll probably be a short stream because I will be on vacation with my child. So, I'm sorry, August 2nd, Friday, August 2nd. So on Tuesday, substantive motions are going to be due, Tuesday the 23rd. Friday, the responses are due. So on Friday the 26th, we'll come together. I'll go through the motions. We'll go through the responses that are available, okay? Then they will go in on Tuesday the 30th, and they will argue them before the judge. We will come together on August 2nd for a recap of those arguments. She says that the jury, if they're moving forward, and she said that, if we're moving forward, then the jury will be seated again on August 5th. Okay, so if they're moving forward, that means when I go to Atlanta on August 13th, we're going to meet in this courtroom in the afternoon. All right, so August 13th, I'll be in Atlanta. We are going to be meeting in the courtroom in the afternoon, if the trial's still going. Otherwise, we're going to be meeting at the meet and greet at Hudson Grill downtown at 6:30 p.m. And I'm going to start posting the details so that everyone can write that down. I am really looking forward to seeing you. I am really looking forward to meeting you there. Okay, I can't wait either. I can't wait to meet you there. In a sad sense, I hope the trial moves forward so I can see this judge and I can see the jury and I can, go to the courtroom and see all this and meet all the lawyers. But I hope that justice is served. More importantly, I hope that justice is served. And I feel in order for justice to be served, then we must have a mistrial. Republic Room, thank you so much for the 1111. Thank you. I really appreciate you. And Republic Room says, congratulations on your sobriety. Thank you. I believe the fix was in for this trial. Judge and prosecution. Maybe fairness is at hand. Maybe. All right. I hope you have better faith in this judge. I have better faith in this judge. What I saw today, I have faith in this judge. The fact that the defense attorneys have held for her fundraisers, that gives me faith in her. It really does. That gives me faith. Thank you, guys. Thanks for the congratulations. I really appreciate it. I'm so happy to be able to share my journey and my 5-year sobriety date with you. Someone said, oh, I can't believe you're going to a bar if you don't drink. Well, the thing is I'm a grown-up, and I have the ability to control myself, so I can actually go anywhere. I can literally go anywhere, including a bar. Crazy. I can go to a bar and not drink. That's a fucking shocker, right? Crazy. What? A grown woman can manage her own life? But man, those comments trying to teach me how to manage. I'm going to stay out the comments from here on out, y'all. Okay, so we're going to meet at the Hudson Grill at 6:30, and we're going to do the meet and greet. I have a ton of Cadillac Law goodies, and I plan on giving those away. I also plan on having some merch. We are going to be launching the merch soon. I hope to bring some of that merch with me to Atlanta. So, to everyone who has decided to stop drinking and to have a better life, congratulations. Anyone who's thinking about it, please do it. If not for yourself, for your liver, okay? Really, for your liver. I mean, my liver feels so much better. If I think about drinking, my liver starts to kind of ache. Ooh. Chris, congratulations on your 4 years. I love that. I love that. Okay, so, Cece, I quit drinking soda a few months ago. I was like an addict, okay? I was constantly drinking soda, and it was all going to my gut. And I feel like my face was looking rounder than I wanted. So anyway, I quit drinking that. I've been on water, although today I did have a hot chocolate that I think had caffeine in it. So I appreciate everyone who's here. I'm Lauren Cadillac, aka OG Cadillac. I've been following this Young Thug trial since a long time ago. I find it so interesting that the state intends on using lyrics against someone. I think it's a First Amendment issue, and it's a First Amendment issue that interests me. That's how I came to this trial. So for all of those who have been with me, Mrs. Mondo, she was one of my first people in the chat ever. Tall Glass Tavanda, everyone who's been here, thank you so much. Everyone who's subscribed, thank you so much. Everyone who's liked, everyone who has done a super sticker, Republic, thank you so much. Thanks to your support, I've been able to buy a better computer and buy a better camera. It is supposed to move with me, but I think I maybe pushed the wrong button this morning. I'm still living by Live or Let Die. John, thank you for your membership. Live or Let Die. Nyax says, do you think the judge will grant a mistrial with prejudice? Okay, so let's talk about that. That's a very good question. Thank you, Trisha. I appreciate that. And Datpot, hello, welcome. All right, so thank you, Trevor. The question is, will this judge grant a mistrial with prejudice? I don't know. Obviously, I cannot if I could psychically be in people's minds, I would have a lot of money. Okay, because I would be able to psychically figure out how to get money. All right, I would be filthy rich. I'm not there. Okay, so I'm not a psychic. But I believe that because there was testimony after the first recusal was filed. So when Weinstein filed his first recusal, that at that time, everything should have stopped. But instead, they had, 2-3 days of Woody and his testimony. The judge, as we already heard this morning, is going to have to unwind that testimony, somehow take back the notes and knowledge of the jurors. And I feel that that is impossible to do. I do not believe that you can just unwind and undo that Woody testimony. Okay, so if the judge agrees with me that we cannot undo and unwind the Woody testimony, then the judge would have to file a mistrial or call a mistrial. The next question arises is, should it be with prejudice? Does double jeopardy apply? Is double jeopardy triggered? Okay, so first question is there a mistrial? Second question is, should double jeopardy, does double jeopardy apply? Should it be a mistrial with prejudice? So I saw an interview with Weinstein on Megan Cuniff's channel, and he made the argument that because the prosecution requested the ex parte meeting, so the prosecution went to the judge and said, we want this ex parte meeting. So because the prosecution did that, then they goaded the defense into filing the mistrial. So because of the prosecution's behavior, we now must have this mistrial. And Weinstein's theory then, an argument from there, is that invokes double jeopardy and it should be dismissed with prejudice. I arrive at the same conclusion, okay? Weinstein and I arrive at the same conclusion. The prosecution forced our hand in calling a mistrial or asking for a mistrial, and therefore double jeopardy attaches. Therefore, this needs to be dropped with prejudice, just like we saw in the Alec Baldwin case. So I don't know if you guys watched the entire 2 days of the Alec Baldwin trial. I sure did. There, it was found that the prosecution had hidden some evidence that could be exculpatory, possibly could be exculpatory. And when the judge heard that evidence, and the judge heard that the prosecution was in fact part of that hiding of the possibly exculpatory evidence, the judge called a mistrial with prejudice. Just like that. So, I believe if you apply the law to the facts in this case, in this YSL case, you have to call a mistrial with prejudice. You have to call a mistrial with prejudice. That's my belief. I am obviously very pro-defense. I am very clearly not on the side of the government, okay? If you come here for unbiased information, you need to just move along because it doesn't exist here. I am very biased against the government and in fact feel that it is my duty as an American to constantly question the government and to not trust anything they say or do. All right, so I believe in that very strongly. So if you want this very unbiased opinion, you ain't gonna get it from me, okay? I believe that the prosecution caused the mistrial. The need for mistrial exists because we know the ex parte conversation happened. Full stop, okay? We know ex parte conversations require mistrial. So we know there needs to be a mistrial. And then the next question is, should it be with prejudice? Should it trigger double jeopardy? And my answer is yes, because it is a mistrial because of the prosecution's misconduct. I am a little surprised that before Brian Steele filed that motion that I just said out loud, which should be a motion, he filed a recusal of the two prosecutors. That is interesting to me. I kind of think that means that Steele thinks they're going to continue on with the case. That's okay. It's okay, in my opinion, if they continue on with the case because they will now have a fair trial. My main issue is, how do you have the jurors come back 2 months later? How do you erase the Woody testimony 2 months later? And how do we know they haven't Googled this? Because quite frankly, at this point, when you've been out of jury duty now for 2 months, you might start Googling things. I don't know about you, but I have this cell phone and it sends me like local news. If I open the web browser, it just will pop up to local news. Well, all of these jurors are in Atlanta. That's their local news. There's been a big buzz on this case for the last month and a half while they've been at home. All right. NYAX. I can't say that. NYAKZ. Thank you so much for the $5 super chat. What argument do you think the prosecution will present to circumvent that argument? And if a mistrial is granted, do you see the prosecution retrying? So if the mistrial is granted with prejudice, they cannot retry. Double jeopardy, no go. If it's just a mistrial, then they can retry, and I do think they would. I do think they would. I'm not sure how the prosecution will circumvent this argument for mistrial, particularly based on their response that they needed 48 additional hours and 7 additional minutes to file to the recusal itself. It was the dumbest 15-point Calibri font response I had ever seen in my entire life. So, I don't know. I don't know Georgia case law. I don't know what they're going to do. Obviously, the counter argument is that the ex parte meeting was allowed. But I don't know. So the judge who recused Glanville, she specifically recused him because he argued the ex parte, or he argued against the recusal motion. She did not recuse him because the ex parte was incorrect. She did not rule that the ex parte is incorrect. So there's no ruling that the ex parte meeting was incorrect. That's going to have to be done in front of this new judge. This new judge is going to have to hear that motion. Okay. Yeah, Miss Love's 8-page motion full of error. The worst 8 pages I've ever read in my entire life. They're not real good at making arguments. They're only really good at winning cases when they have judges winning the cases for them. I loved watching Miss Love today. Yes, you can get a mistrial with prejudice for judicial misconduct, of course. With that, be all defendants in the indictment or just the 6? I don't know, Memphis. I don't know. I'm assuming just the 6. Because just the 6 are in trial right now. And just the 6 have been affected by it. The rest have their own trial headed their way. MI86 says, I may be off, but weren't they granted about $5 million for this case? I don't know. I don't know what the government's budget is. The government's budget is limitless. They print the money, dude. So they do whatever they want. I don't know how many millions they have for the prosecution of this case. And, you know, again, if I was a Fulton County taxpayer, I would be at that courthouse in protest on a damn near daily basis, okay? Anytime I didn't have to be actually doing my job, I would be lit. Another thing that I find really interesting is that the Fulton County courts hear both criminal and civil cases. So here in Dallas, in the larger counties in Texas, we have separate criminal and civil courts. Okay, so the bigger counties have separate civil and criminal courts. In Fulton County, the judges are doing civil and criminal but they have special probate courts. So that is really interesting to me. I don't like that. If I was a defendant, I would want to be in front of a judge that only does criminal, because it's a lot. That's a lot of laws. It's a lot of laws the judge has to know and apply, and I just, that would make me uncomfortable. I like the idea of having a criminal court that only does criminal and a civil court that only does civil, but that's not what they have there. They do both. So that is an interesting thing that I found out about Fulton County, and I imagine, I don't know if you've been around my channel, I've told you really that emotionality that we see out of Glanville, that erratic emotional behavior is something we see more often out of civil court judges. We don't really see that in criminal court. I've seen it sometimes in civil court. I've seen it in probate court, but never, usually not seen in criminal court. So when I found out that they're also doing civil, it made a little more sense to me that he could be so emotional in his rulings. There's really not supposed to be feelings in this. It's the law. It's black or white. You know, there's no feelings in the law. And certainly there should be no feelings for a judge as it pertains to the law and their case. So, I appreciate you all so much. Thank you for being here. Thank you for hitting like. Thank you for hitting subscribe. I'm almost to 6,500 subscribers. I'm trying to get there by the end of the weekend. Trying to get to 10,000 by the end of the year. If you guys can help me by sharing with your other friends who are into trials, I would definitely appreciate that. Hippie used to say that they were given $5 million, it was all spent during jury selection. No doubt. All right, guys, I appreciate you so much. Thank you for joining me today. I will see you next Friday at 10 a.m. Thank you for your likes, your subscribes, your super chats, your Cash App contributions. Thank you for everything. Thank you for being here. I am Lauren Cadillac, aka OG Cadillac, and I am signing out.